very distinguished Attorney General for India, Mr. R. Venkatramani, Dr. Ashish Bharadwaj, Dean of BITS Law School, Dr. Anshul Pandey, founder PanScience Innovations, and Soumya, Hardik Dave, CEO of Nyay AI, and distinguished guests who are present here this morning. Honestly, I'm delighted to be a part of this revolutionary launch. And by revolutionary, I do not use the term lightly. I mean transformational in scope and immediate in impact. Revolutionary because it is not just about introducing another piece of technology into the legal landscape. It's about fundamentally reimagining how legal research, practice, and adjudication can evolve with the convergence of artificial intelligence and institutional best practices to build capacity and enable efficient, accessible, and intelligent legal systems. Since this is not a lecture, I will take the next 10 minutes or so to briefly touch upon three postulations. First, accepting reality. AI is here. Coming from the judiciary, 25 years as a judge and over 20 years before that as a lawyer, I would like to first reflect on the digitization of the judicial arm. In our judgment in Sarvesh Mathur versus Registrar General of the Punjab and Haryana High Court, the Supreme Court mandated the provision of virtual and hybrid hearing facilities across all high courts, district courts, and tribunals. Yet when data was collected through affidavits, what emerged was troubling. A consistent pattern of tech aversion, even resistance, not just among court staff, but among the bar. This hesitation over something as basic as video conferencing technology highlights a bigger concern. How do we responsibly integrate emerging technologies like AI into this ecosystem? Because we all should be clear that AI is no longer emerging. AI is here. And I think the only way forward is to take decision-making on technology and its implementation out of the hands of judges and lawyers. I say conscious of the fact that I was chairing the E-Committee for 5 years, and then 2 years as Chief Justice of India when I was leading the technology revolution in the Indian judiciary. But the problem is that it depends too much on single individuals. And how do we then make it as part of our processes and systems? Now that I'm gone from the judiciary, I hear so very often about stories of judges are saying that, well, now that the Chief Justice has left the scene of digitization in the judiciary, we can get back to our paper files. That has to change. And the system can't depend upon either the willingness or unwillingness of a single individual to adopt technology. The judiciary is already on the positive front beginning to see AI as part of its operational landscape. We have all seen examples of AI being used in judicial decision-making. In Colombia, a judge used ChatGPT to assist in drafting a judgment involving an insurance claim for an autistic child. In India, the Punjab and Haryana High Court referred to ChatGPT for a broader perspective in a bail matter involving allegations of assault. These instances are no longer speculative. They are real, and they show how AI is becoming a part of the decision-making environment. Similarly, a study by the Center on the Legal Profession at Harvard Law School found that in high-volume litigation cases, particularly in large American law firms, dealing with employment or consumer disputes, the use of automated complaint response systems reduced associate time from 16 hours to just 3 to 4 minutes. This freed up resources and allowed human lawyers to focus on strategy, analysis, and client advice. I remember when I began my career in a Wall Street firm, Sullivan and Cromwell, if I was asked what was the nature of my work, I was a little embarrassed to answer because all that it entailed doing was, quote unquote, pushing papers. But no longer so. As Anshul said, AI is not going to replace human beings. It's going to free up time for real creative work which experienced professionals have to discharge. But these examples demonstrate the practical benefits AI can offer. But they also raise fundamental questions about the limits of AI's role in legal decision making. And my second postulation, therefore, is AI is here to augment, not to replace. There are cases where AI clearly cannot replace human judgment. For example, in the Secretary Ministry of Defense versus Babita Punia, a judgment which I scribed just before the COVID-19 pandemic, the Supreme Court ruled that female officers must be granted equal opportunities for permanent commissions in the Indian Army and then in the Indian Air Force and the Indian Navy. That's how you see women at the borders commanding platoons of male and female colleagues. You see them as Air Force pilots carrying out a mission and returning home safely aboard a Rafale fighter. Or you see them in naval submarines now. Now, this decision was not merely a straightforward application of military regulations. It required the court to grapple with deeply entrenched gender biases, societal norms, and evolving principles of equality and dignity under the Constitution. This highlights that while AI can assist with routine or data-driven tasks, it cannot but replace the nuanced understanding and empathy that human judges bring to complex social issues. Or just the week that I retired, we had a young student with an 88% disability who was denied admission to a medical college. AI would have answered possibly by saying that the rules are all against that student. Or we said, rules or no rules, this student has to be admitted to medical school. Because if that student suffers from 88% disability, it's for us as human beings to make those reasonable accommodations for him or her to succeed. Yuval Noah Harari captures the nuance of AI's power and risks very well. In his book, 21 Lessons for the 21st Century, he describes how algorithms, when trained on vast amounts of personal data, could begin to understand us better than we understand ourselves. I always believe that my spouse understands me much better than I understand myself, and likewise, me understanding my spouse better than she understands herself. I'm not sure she agrees with the latter part, though. These systems might influence our decisions on what to buy, how we vote, and for the youngsters, even whom to date. But more worryingly, if applied without checks and systems like the judiciary, they could shape outcomes that deeply affect lives. Harari reminds us that the threat is not that algorithms will become evil, but that we might begin to trust them blindly. That kind of uncritical dependence is something we must avoid. And that's what we are taught intrinsically as judges and lawyers. Never believe what you see or read. What is apparent may not be real. At the same time, responsible use of AI remains a major concern. Not all users of AI in legal systems have been responsible. A year ago, a federal judge in Manhattan fined a lawyer $5,000 for filing a brief that contained fictitious case law generated by ChatGPT. Cases such as Verghese versus China Southern Airlines and Shaboon versus Egyptair did not exist at all. They were fabricated by the AI and included without verification in a personal injury suit involving Avianca Airlines. This example is not just about shortcomings of AI alone. It's about the absence of organizational policy, the lack of review mechanisms, and the failure to uphold professional responsibility. When I was studying law at the Campus Law Center in Delhi University, years and years ago, we had this fellow colleague. There was a Hindu law question in the Hindu law family law paper. So we asked him, "Bhai, kya likha?" So he said, I wrote that the answer was in the judgment of the Supreme Court and the Bombay High Court, he said, I think, in Arjun versus Bhima. So we asked him, what is Arjun versus Bhima? He says, I don't know. So we said, but where did you get this judgment? He says, you presume that the examiner will know that there is no such judgment. So human beings did that before AI, and they'll continue to do that after AI as well. So it's not something which is peculiar to AI. it's peculiar to the human mind. This leads us to the crucial role of governance around AI use. Firms, institutions, and individuals must implement clear policies for using AI responsibly. These include internal guidelines for verification, secure handling of client data, compliance with data protection laws, and routine human oversight. And my third and final postulation, the concept of responsible AI. This is where the concept of responsible AI becomes important. Professor Virginia Dignam from the Delft Design for Values Institute explains, AI systems are not responsible in themselves. Responsibility lies with the humans who develop, deploy, and apply them. So they lie with Anshul and his team. Responsible use of AI requires us to act on two key priorities. Firstly, capacity building, and that's what Palette is designed to deal with. This center is fundamentally about empowering the legal ecosystem by building core competencies in artificial intelligence, data science, emerging technologies, and ethical standards. It is about preparing tomorrow's legal professionals to not just coexist with AI, but to work intelligently alongside it. And that's why this partnership with BITS is so crucial, because it's not just about technology. It's not just about law. It's about creating new colors from this palette, which goes beyond technology and law while synthesizing the two. I remember that in last year's remarks at the Indo-Singapore Judicial Tech Conference, it was really a cutting-edge conference, Dr. Anshul Pandey from PanScience Innovations was also a panelist. There was considerable emphasis on legal education and the need to reimagine capacity building. I recall Dr. Dirk Harting from the Singapore judiciary stressing the importance of developing the T-shaped lawyer, T as in technology. A lawyer with deep domain expertise in a particular field of law, which forms the vertical stroke of the T, along with a broad understanding of related disciplines such as technology, data science, programming, and ethics, which form the horizontal stroke of the T. This is no longer optional. It is a need of the hour. Lawyers today must not only interpret statutes, but also understand how AI systems arrive at their recommendations. Just yesterday, I asked a young intern who was assisting me to give me a research note on conflict of interest in financial markets. In less than 2 hours, she was ready with an 8-page note. And the first message which I sent her on my WhatsApp chat was, I hope this was not driven by AI or Meta. She did it on her own. Brilliant student. So lawyers must today not only interpret statutes, but also understand how AI systems arrive at their recommendations. This includes knowing what data is being used, what assumptions are built into algorithms, and how to critically evaluate or challenge their outputs when necessary. Without this foundational understanding, lawyers risk either over-relying on these systems or rejecting them outright due to the fear or skepticism of their use. Bridging this knowledge gap requires a fundamental mindset shift in how we approach education and professional development, not just for students, but across the legal profession and allied fields. We must all engage with concepts of digital literacy, algorithmic accountability, and ethical reasoning. Secondly, industry and stakeholder collaboration in AI is equally important. Palette itself is an example of such collaboration between BITS Law School and PanScience Innovations. What is heartening today is to see the kind of representation this event has brought together. When we speak of the legal community, we often limit our thinking to judges, lawyers, and courts. But we must expand that definition to include legal technologists, researchers, academic leaders, law students, policymakers, in-house counsel, design thinkers, and even those working on legal aid and access to justice. During my time as chairperson of the E-Committee of the Supreme Court, I saw firsthand the importance of this collaborative mindset. Phase 3 of the E-Courts project, which eventually led to a budget of over 7,000 crores being sanctioned by the government of India, was the result of collaboration between civil society, the Indian judiciary, and technology and domain experts outside the judicial system. When I asked Dr. Anshul Pandey to come and work on AI for the Indian judiciary, I was fascinated because they spent close to a year and a half understanding the Indian legal system. And the end of that year and a half, when they had designed their first module, I remember what he said to me. He says, we have designed modules across the spectrum, but I've never found anything as complex as the Supreme Court's procedural requirements. So you have to, as technologists, step into our shoes. But equally, as administrators, we have to get off our shoes and allow them to get into our shoes. Too often we think in the Indian judiciary that we know everything. We honestly don't. And it's time that we allow these decision-making processes to be taken away from us and to be vested in experts who count. I have seen firsthand the importance of this collaborative mindset. We have worked not just with judges and registry staff, but also with the National Informatics Center engineers, law school faculty. We had an MOU with IIT Madras and private developers. This cross-pollination was essential to design digital systems that were functional, scalable, and rooted in ground realities. But we must also acknowledge that technology alone does not solve all problems. AI assistance in routine tasks such as summarizing of cases, organizing evidence, or drafting responses is well known. AI assistance in routine tasks such as these and other aspects will really enable us to devote adequate productive time as young lawyers and senior professionals, both. But what AI can truly achieve beyond the repetitive is a question that can only be answered through collaboration, through seminars and conferences and interdisciplinary dialogue and continuous knowledge sharing. This is not just a national issue. Even internationally, there's a growing momentum to frame ethical and legal standards around AI in justice systems. For instance, the European Commission has adopted guidelines for the ethical use of AI in the judiciary, emphasizing transparency, explainability, and non-discrimination. It is encouraging that Palette actively promotes collaboration, recognizing that sharing knowledge and best practices across borders is essential for developing responsible and effective AI frameworks in justice. I've been reading a book, in conclusion, let me say this. I've been reading a book by Richard and Daniel Susskind on the future of the professions. And they made a point which I must share with you as I conclude. In a print-based industrial society, the professions played a central role in the sharing of expertise. In a technology-based internet society, increasingly, capable machines operating on their own with non-specialist users will take on many of the tasks that have historically been the preserve of the professions. And therefore, as we conclude, let me just throw up some questions. Are courts places or are they services? Do people really need to converge in physical spaces to resolve disputes? We've already implemented virtual courts in the Indian judiciary, vulnerable witness deposition centers, where a victim of child sexual abuse or a woman of gender violence who has been subject to gender violence doesn't have to be in the courtroom to confront the aggressor, or online dispute resolution. We have spoken about post-colonial societies. When I was graduating from St. Stephen's, we spoke about the challenges of a post-colonial society. 2 years ago, we spoke about the post-truth world, where truth itself is what you manufacture. There is no objective truth. We are now moving to a post-professional society, which will require digitization of the professions, the routinization of professional work, and the demystification of professionals. How we use technology in our professions is in our hands. And I'll only conclude with what a very distinguished writer by the name of Anthony Kenny said in a book called What I Believe in 2006. Technology, he said, puts the sins of omission as immediately and inevitably within our power as it puts sins of commission. But I think these are unique ventures which are now being pursued, and they are a sign of changing India. And I hope that they will be a forerunner of a changing legal profession. The legal profession all over the world is hopelessly behind its times. Judicial systems are horribly behind times. And I think it's innovations like this which can aspire to make our legal systems more in sync with the times and the judicial system less of a laggard and more of a forerunner for change. So I thank both Anshul and Dr. Ashish Bhardwaj and the entire team for putting this together and present you with my best wishes for your success. Thank you very much.